Good morning. Are you Mark Anthony Hebert?
Yes, ma'am.
Mr. Hebert, best you can, please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. You can put your hand down. Mr. Parker, will your client waive the formal reading of the motion?
Your Honor.
Mr. Hebert, in cause number 25 DCCR 0455, I have a first amended motion to revoke your community supervision. It shows that you were placed on probation September 15th of 2025 for the third-degree felony offense of driving while intoxicated, third or more. And that was a 5-year term in prison that was probated for 5 years. Is that correct?
Yes, ma'am.
The motion alleges that you violated your probation. Count one alleges that you failed to report as directed to the probation department January 13th of 2026 and December 30th of 2025. And is that true or not true?
Yes, ma'am.
True or not true?
True.
Thank you. Count two alleges that you failed to report to the counselor as directed on January 12th of 2026 and December 16th of 2025. And is that true or not true?
True.
Count three alleges that you failed to report to your administrative hearing that was held on February 2nd of 2026. And is that true or not true?
True.
Count four alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true?
True.
I mean, you look like your head.
He's self-employed and he's had a business for a while. I think business was slow. He's part of the hesitation is he's had some serious health issues. That's why the bond. That's why he's hesitant about answering.
Okay.
Not true or true.
So you don't have to say true just because you're here. So is it true or not true that you failed to work faithfully at suitable employment and provide verification of that?
Not true.
Okay. Count five alleges that you failed to submit to alcohol or drug screening January 29th, January 23rd, January 21st, January 13th, and January 9th of 2026. And is that true or not true?
Yes, ma'am. True.
You did all these dates backwards on this one. Count six alleges that you failed to comply with the program guidelines and rules of JCDI program. Is that true or not true?
True.
Count seven alleges that you are behind in your court assessed fees as of February 2nd, 2026 in the amount of $168. Is that true or not true?
Pretty sure I've paid up on that.
Okay, be not true on seven. Count eight alleges that you provided a urine sample May 11th of 2025 and April 13th of 2026 that tested positive for marijuana. Is that true or not true? Count nine alleges that you provided a urine sample May 11th of 2025 that also tested positive for methamphetamines. Is that true or not true?
True.
And count 10 alleges that you provided a urine sample also May 11th and it tested positive for alcohol. Is that true or not true?
True.
All right. Did you enter your pleas of true to counts 1, 2, 3, 5, 6, 8, 9, and 10 freely and voluntarily?
Yes.
The ones that you pled true to, did you plead to those freely and voluntarily?
Yes, ma'am.
And did you plead true to those because they're actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to counts 1, 2, 3, 5, 6, 8, 9, and 10 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. However, I'm going to reset your case for sentencing. We will have a sentencing hearing. I'll get the probation department to do an updated report. Ms. Malfino, if you have any, I wouldn't imagine whatever you would have would take very long. If you wanted to have any issues with regard to 4 and 7, you can bring witness and we will get your case taken care of at that sentencing hearing. Anything that you think is important for me to know on your sentencing, make sure you get that to Mr. Parker. He'll present it to me on your behalf when we come back. And
Sure.
For probation, this is unagreed. All right, you can go back with the bailiff.
Mark.
I'm better time down in heavens. Say to you.
Who's that right there?
That
Oh, okay.
So
What about Donald DeRusso?
we've done it. One time. It was all that. That's Jewish. Right? I don't know that's Jewish. It's like
Interjects on that.
Oh,
so I said, your cousin, because we're not blood. I said, if you're rich, if you're rich, it's that you think you're funny. He said, yeah, he's my favorite. Yeah, I guess you don't have it. Okay. I'm just-
yeah. So much. You know, okay. Are you ready for them to bring Donald DeRusso? Right. Donald DeRusso? Donald DeRusso.
I call him Duraso.
DeRusso. DeRusso.
I don't know which right. He answered. And again, she's already emailed the.
Thank you. Let's see, and are we going on count one only?
Yes.
That's fine. Judge, his priors make him habitual by law, but he didn't receive even half the time he is on this case on those.
All right, so are you Donald DeRusso? And will the client waive the formal reading of the indictment?
It will, Your Honor.
Mr. DeRusso, in cause number 26 DCCR 0758, you're charged with the state's going to proceed on count one only. It alleges that you committed the second-degree felony offense of aggravated assault with a deadly weapon, and that's from April 9th of 2026. And how do you plead to that charge?
Yes,
Are you pleading guilty freely and voluntarily?
yes,
And are you pleading guilty because you did what they've charged you with?
yes,
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
yes,
Do you fully understand them?
yes,
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
yes,
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
yes,
State tenders number 1.
No objection?
It's admitted. Is there any evidence that Mr. DeRusso is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the second-degree felony offense of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification. That shows that this was an agreement that I followed, so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right. Good luck to you, sir. You can go back with the bailiff. Oh, wait. And I am making an affirmative finding of a deadly weapon. All right. You can go back with the bailiff. Goodness gracious. Need a recording of myself. Mr. Lewis, you've got Avriona Dorsey.
yes, ma'am.
Good morning. Are you Avriona Dorsey?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes, sir.
Ms. Dorsey, in cause number 26 DCCR 0756, you're charged with a first-degree felony. You guys marked off second, but is it a first?
It is a first, Judge,
With y'all's permission, can I change that
Yes, ma'am.
admonishment
because it's burglary with an
with intent?
to commit aggravated assault.
So you're charged, Ms. Dorsey, with a first-degree felony offense of burglary of a habitation with the intent to commit another felony, aggravated assault. And that's from April 11th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes.
Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
Now, it looks like the agreement that you've reached is for a 10-year deferred probation fine.
We didn't really discuss fine, Judge.
Typically, there's going to be a fine of $500. I'll look at that at sentencing. Also, part of your agreement, it looks like, is that you're going to enter and successfully complete the cognitive track of the ISF program. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Ms. Dorsey is not competent?
No.
Right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily.
Yes, ma'am.
Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back for sentencing.
Okay.
Right? You can go back with the bailiff.
Judge, I think we've agreed if it's the court will accept 8 on Mr. Harrison, we can
Yeah.
call him back up.
All right, Kenneth Harrison. Thank y'all.
Kenneth Harrison.
And so where did I put on Harrison? Did we go through the whole motion before I stopped and started looking on it? Let me find it. Oh, yeah, we already went through. He pled true to 1, 2, 3, 7, 8. Okay, state abandoned.
This is one of the most significant moments in the hearing. Kenneth Harrison has just been sentenced to 8 years for aggravated robbery, and the judge goes beyond simply announcing the punishment. She explains exactly what was at stake. According to the court, Harrison could have faced a dramatically harsher outcome, potentially spending decades behind bars. Legally, the case becomes even more serious because of the affirmative deadly weapon finding, which can affect future consequences and restrictions after release. But notice the judge's warning about firearms. That isn't casual advice. It's a direct reminder that future violations could lead to even more severe penalties. Here's a question for you. When someone receives what the court considers a favorable plea deal, should the focus be punishment, rehabilitation, or both? The judge clearly expects this sentence to serve as a final opportunity before the consequences become much harsher. Now, let's return to the courtroom as another probation-related matter takes center stage.
And sign these. Did you go over them with Mr. Lewis? Do you fully understand all the documents you signed? And do you understand, if I follow this agreement, that you will be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Harrison is not competent?
No.
All right, sir, I'm going to find that you entered your plea of true to counts 1, 2, 3, 7, and 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated robbery. Sentence you in accordance with that agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. I am making an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you have waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or how long that lasts, you can talk with Mr. Lewis. So, Mr. Harrison, in my opinion, you're getting a great deal today. You could have gone to prison today for anywhere between 5 years and up to the rest of your life. And I know you've probably been hearing out of the jail what's been going on with the cases where people have guns and are continuing to use them and possess them. So take advantage of the time that you have, do something better with your life. And when you get out, don't possess a gun. Don't be around anybody that's possessing a gun, because if you are and you're here in Jefferson County, it's going to be a whole lot worse than today. Do you understand?
Yes,
All
ma'am.
right, good luck to you. You can go back with the bailiff. You'll get credit for any time you've been in custody. Let's see, what about Jermaine Reddo?
It's that one, Judge. Meaning Philip talks like that one.
Do we need him out?
I don't.
Judge, what we did, this is the one, he had new charges that were filed. It was a felon in possession of a firearm and the things that you were concerned about. I checked with our intake division. They found they refused those cases based on complaining witness,
Okay,
found them to be unreliable.
okay.
So what I would propose to do would be to just go on the technical violation, which would be well, it was 2:09 p.m. outside of his residence. He was arrested for this, and it was charges were not filed. So I can either dismiss the motion or give him a jail sanction for the time that he's been on.
I mean, obviously, should that be AM? Because being somewhere else at 2:09 PM is not a violation. I mean, if everything was.
It was AM. That was just a typo in the MTRP, but that's the only allegation that we would probably move forward on.
Let's get Mr. Reddo, please. I mean, you can file a motion to dismiss it and I'll sign it, but I want to talk to him real quick before I sign that. I created a new document, but I'm not doing anything with it. There's really nothing to, this is his second. How did the last one get dismissed? Well, third, is that the? So on these new offenses, the possession of a firearm allegation, is that something that only that uncooperating witness could prove up, or is that something that law enforcement?
There was a question about whose weapon it was.
Because this is the second MTRP that has to do with,
Well, the first one was dismissed because the only violation, allegation was that he possessed a firearm and fell in possession of a firearm, and he had been on deferred, so he wasn't.
right. And, but still shouldn't be possessing a firearm while you're on probation, regardless of that. So, Mr. Reddo, probably what's going to happen today, based on the information that I've received from the district attorney's office, is that that motion to revoke your probation is going to be dismissed. This is the second time that you're kind of getting away with doing something that you probably shouldn't. I want you to understand at this point, I'm going to order that you are on 0 tolerance on your probation, that you will be on the high medium caseload and required to do everything that you're supposed to be doing. If you are caught with a firearm, if you're around anyone with a firearm, I don't care who it belongs to, ownership. If you're around it, it is going to be a violation of your probation. I'm ordering a condition of your probation is that you are not allowed to be around or in possession of a firearm in any way, not in the same house as one, not in the same car as one, period, none. So there won't be any question if there's an issue that keeps popping up here with regard to firearms, that if you're around one, it won't matter whose it was or whose it belongs to, it's going to be a violation. And it's not going to get dismissed. You're going to end up going to prison. Do you understand? You're on a very serious probation, and I have some concerns about what's going on. But you're back on that probation. You still have the same opportunity to be successful. It's going to be up to you to quit doing whatever it is that's going on. Okay. If you have an issue with whoever it is that you're dating or married, then you need to get away from that, because that's going to end up getting you into trouble. Right? Okay. You can go back with the bailiff. Angela Reyes. What? In the West, they're being dismissed. Are these the three she's playing on?
Yes.
Okay. Thank you. That needs to be.
Oh,
Good morning, ma'am. Are you Angela Reyes?
Yes.
And will your client waive the formal reading of the indictment in each case?
she does, she does.
Ms. Reyes, you are Angela Reyes, correct?
Yes, ma'am.
And Ms. Reyes, in cause number 26, DCCR 0265, you're charged with the third-degree felony offense of obstruction or retaliation from December 22nd of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
And then in cause number 26, DCCR 0787, you're charged with a second-degree felony offense of assault on a peace officer. And that's from March 17th of 2026. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
And then finally, in cause number 26, DCCR 0788, you're charged with a third-degree felony offense of harassment of a public servant. And that's from March 17th of 2026. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes.
In all three of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? And it looks like the agreements that you've reached in these three cases would be for you to receive 10-year deferred probations in each case. There would be fines in each case of $1,000. You would be ordered to.
Your Honor, I'm sorry. I don't know that it was the intent of the state to have a total
Three.
$3,000 fines. I'd be willing to waive the fine on 2 of those cases. We just have.
So a $1,000 fine in, let's just put it in 0265.
Yes.
And there would be no fine in 0787 and 0788. Is that your understanding?
Yes, ma'am.
Is it also your understanding that you would submit to a mental health evaluation and follow any and all recommendations and treatment, be on that mental health caseload at the
Yes.
probation department?
Absolutely.
State tenders number 1 in each case.
No objection, Judge.
It's admitted in each case. Is there any evidence that Ms. Reyes is not competent?
No objection.
right, ma'am. In each of these cases, and also part of the agreement is that the state would dismiss all of the other remaining cases. Is that your understanding?
Yes.
Then I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence to find you guilty. However, I'm going to reset your case so the probation can do a pre-sentence report and possibly get that assessment done or at least partially done so that we know exactly what you need when you are released on probation when we come back for sentencing.
Okay.
Okay, you can go back with the bailiff.
Thanks.
Thanks, Judge.
Yeah, well, so I'm trying to find a new opinion. You know, there's a reason. No, what the contents of it, what the contents of it's an entrance. We'll claim you. All right. I'm the office and was thinking. Now I'm going to. So.
Any cases to dismiss?
Simply fixing. You know, any more here. I think. Listen, Sherman's. People that have, I think, always good debates.
All right, Jameldrin Wilridge, sentencing.
Marvin.
This is my thoughts. It's just kind of. Yeah, it's-
Right, are you Jameldrin Wilridge? So we're here. Mr. Wilridge has he's on probation in 3 cases, 18-28743, 28744, and 30139. And then there's a new offense of burglary of a habitation in cause number 25, DCCR 1804. And there was an agreement that was reached and he entered a plea of guilty to that burglary of a habitation case. The agreement was for a 10-year deferred probation, restitution to be determined, and that those motions would be dismissed. There was an issue between obviously when he pled and now, which required me, I revoked that bond because he was arrested on May 26th in Chambers County for a 3rd-degree felony and a Class B misdemeanor. So obviously that.
Kind of nullified from all of our position where we were with that agreement, Judge.
Right.
So you know.
Okay, so where are we? I mean, I'm going to at this time reject the agreement formally so we can start all over. You guys negotiate whatever y'all want to do. If we need to get more information about that Chambers County case, but obviously I'm not inclined at this point. I see no reason if those allegations are true, that Mr. Wilbridge would get another opportunity on 3 felony probations with now the new burglary of habitation here. And while literally days after he entered pleas here, went and was at a minimum in a county that he wasn't supposed to be in without permission. and arrested for those offenses. So my thought is, do you have any information on those yet?
No, Judge, because when we broke last time, it was primarily, obviously not knowing that was gonna happen in Chambers County for the restitution in the burglary. Because we
Right.
all had the discussion about how could tennis shoes cost that much.
Right.
And I have spoken several times with Mr. Riley, who the court knows is an excellent PSI writer. And he assures me, and through an affidavit from the complainant in that case, that that's what the restitution amount is. So I feel like we could ask for that and see if he'll pay it, and so be it. Then obviously the new offense came up, which then put us all kind of back at square one. The court is aware that I have always been a little bit more outgoing with Mr. Wildridge, wanting to give him an opportunity. I'm not suggesting I still don't want to do that, but I certainly understand the position that we're all in. I mean, the files are just stacking up.
Yeah.
And
I mean,
And Judge, only thing I can say in that regard is that, of course, I've dealt with him for a long time in this situation, and he understands it was inexcusable for what happened in Chambers County. But I will say that it's the first time that since then that he's actually opened up to me as far as asking for the type of help he needs for any underlying issues that may be there. And it's something that his family was actually in the position to try to get started when the whole bond situation occurred. But of course, he turned himself in, did what he's, complied with your orders.
And that, per our conversations, I think, Judge, it's important to note that that has to do with underlying mental health issues that go directly in correlation to his behavior. Although it doesn't excuse his behavior.
no, it
Yes,
doesn't.
right.
And I guess, you guys know, he's been on probation since 2018.
Right.
There's been every opportunity to take advantage of any help. It's not like he just did all this and we say, okay, well, now let's do this. We've got help for him. It's been years that we've gone through motion to revokes that have been dismissed, and
The only thing I can say is a lot of times in these type of situations, of course, the help doesn't work unless the person is ready for it. And of course, like I said, this is the first time he's opened up to me as far as trying to get that. And a good thing for him, he does have the support system there that he can try to get that help.
and that's so great. And it's also such a shame at the same time, because I'm guessing he's had the same support the whole time. It's not like people are just now stepping up and saying, let's help him out, right? They've been there the whole time. And here we are with our 5th felony in Chambers County while you're on probation for 3 here. Here's what I need. I'm not going to do anything today. I want to find out, see what you guys can find out about Chambers County, what the status of those offenses are. Get Mr. Lewis whatever you can, so that I can also have a little, even if it's just a PC, so I can see a little more about what the underlying offense allegations are, and then we can kind of reconvene and I would see, I guess, where, if you guys want to try to tell me what some agreement is, I'll see if I'm willing to go along with it or not. Obviously probation, I value your opinion. And so,
More likely than not, Judge, if it's okay with the court, probably will not come to you with any type of agreement, maybe just more of a conversation. Obviously, we're all aware of the situation that all of us are in right now with respect to individuals this age that have been given multiple opportunities and what else going on. So
we're also going to go through, we can do it. I don't know, there probably needs to be amended motions on those 3
to add those.
to add those allegations. And I'm not going to just sign a dismissal on those motions. I want to go through each and every allegation of the motion, get pleas of true or not true, and then we'll go forward. So between now and then, if you can get, I guess, any type of hearing done so that we can get those new allegations in the hearing, in the motions to revoke, we'll go through those at the next court date, and then we'll see where we are from there.
You get that.
Okay. All right. Thank you. Go back to the bailiff. It looks like it's David Hale. Did we do David? David Hale and Mr. Lewis. No, there's no paper. You guys haven't reached, there's no agreement on Mr. Hale, correct?
No, Judge, we're gonna be asking for some more time, to be honest with you.
Okay. Good morning, sir. Are you David Hale?
Yes, ma'am.
This is 26 DCCR 010.
Today's courtroom session showcased several very different outcomes, but they all revolved around one central theme: accountability. We saw probation violations admitted in open court, felony defendants entering guilty pleas, negotiated agreements resulting in prison sentences, and judges carefully weighing whether individuals deserved another chance. Some defendants received deferred probation and an opportunity to prove they can comply with strict conditions. Others were sentenced directly to prison after accepting plea agreements. Perhaps most notably, the court repeatedly emphasized personal responsibility, especially when prior opportunities had already been given. Throughout the hearing, the judge balanced punishment, public safety, and the possibility of rehabilitation, reminding each defendant that future choices will determine what happens next. These cases illustrate how probation, plea agreements, and sentencing decisions can dramatically alter someone's future in a matter of minutes. If you found this case as intense as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more powerful courtroom breakdowns.